All right, so now we're recording.
Okay.
Okay, yeah, maybe. So, welcome to our guest speaker on copyright this afternoon. As you may be able to tell from looking at the backgrounds, we are actually in the same office, so it's going to be very difficult for us to look at our computer screens and look at our cameras instead of looking at each other across the room. So if you see us looking away, that's what we're looking at. We're looking at each other in the same room. Anyway, I am delighted to welcome Rachel Miles to be our guest speaker on copyright today. Rachel is the Digital Scholarship Librarian at Kansas State University. And specifically, she works in the Center for the Advancement of Digital Scholarship. And part of her role as the Digital Scholarship Librarian has been to become an expert in copyright. So that's why, and it's that capacity that I asked her to be here today to talk to us about copyright in libraries. Rachel is also a NASIG member, so we just saw each other at the NASIG conference a couple of weeks ago. She's also a SLIM alum. So I will stop talking now and mute my microphone, and I will let Rachel take it away.
All right. Thank you for that introduction, Dr. Sutton. I'm really happy to be here and to help anybody understanding copyright law, especially as it pertains to work in libraries. I think that my experience and expertise in copyright can translate into any type of library setting. So, I'm really fluent in the law and some of the best practices, especially in fair use for different types of fields. So this can really translate into any discipline in almost any setting. What you really have to be careful with is every single situation is going to be different, and you start to understand legalese a little better when you start working with these types of questions that I work with. And I think that since every situation is different, one of our favorite things to say is it depends. So it depends because it really truly does depend on the situation. It depends on the context. And then if anything changes in that situation, then you have to reevaluate again. So copyright can be very complicated, but I think that it can also be a tool that's very empowering. It's only really complicated because lawsuits make it seem that way. And when you start thinking about it in more of a common sense way, it's not too bad. So I want to get started talking about, there's two sides of copyright that we tend to address in our classes, in our workshops, and in consultations. One side of it is how do we reuse copyright works legally and ethically? And the other side of it is how do I manage my own copyrights as an author and as a copyright holder? And if you have created anything in your life, which you have, from grade school, you were drawing pictures probably, you're a copyright holder. Copyright is automatic in the United States. And as soon as something is fixed in a tangible medium of expression, that is when it becomes legally holds that copyright. So you likely have hundreds, if not thousands, of copyrights. If you have taking photographs, if you compose music, or you're writing papers, you hold the copyright to all of those works. So we can get started. I am going to show some slides from a previous presentation that I've done, just to give you more of a visual aid. And I've done a lot of different workshops, but I tend to stay on a very standard level and maybe change it a little bit depending on who I'm presenting to. So I'm going to go ahead and share my screen. Let's see here. Okay, I'm guessing that's coming up. She gives me the thumbs up. All right, so part one is reusing copyrighted works. And so that's what we're going to focus on first, is how do you reuse others' works without worrying about, getting sued. So there's something called the Framework for Analyzing Any U.S. Copyright Problem. It was developed by two attorney copyright librarians at Emory and Duke universities, Kevin Smith and Lisa Macklin. Kevin Smith is now the dean of the KU libraries here in Kansas. I know a lot of you are probably not all in Kansas. KU is University of Kansas. So this framework was developed, and it's supposed to be followed on a step-by-step basis. So whether or not you've already used the work or are planning on using it and you have it in your hand now, digitally or physically, or maybe perhaps you are thinking about reusing works, you want to use photographs in a paper or in a blog post or something of that nature, this is the framework that you should be following. So the first question is, does it have copyright protection? So there are things that have copyright protection that are copyrightable, and there are things that are, whose copyright terms have expired. So they are now in the public domain. And if that is the case and those questions can be answered yes, then you don't have to worry about infringing anybody's copyright. Now, you do still have to worry about any types of plagiarism issue, and there is confusion between copyright infringement and plagiarism. The biggest difference I will tell you is that plagiarism is an ethical issue while copyright is a legal issue. And you're not going to go to jail for plagiarism, but you might get an F on a paper, or you might get kicked out of your class. There's university policies in place that have those policies in place to prevent people from doing that and have consequences for that. So moving on to what we're going to do now is go to that first step, and I'm going to kind of work through how do you determine copyright status. The other three steps I'm going to get to, but I'd rather go through them kind of step by step. So step one, determine copyright status. Sarah, do you think that we have any questions? I know that this is being recorded, but do you think that students will have questions? Let me know.
I will. If you want to, the only comment I have at the moment is if you want to switch to presentation mode on your PowerPoint, you can. It won't hurt the recording or the what the students are seeing.
Okay, so I'm switching to PowerPoint mode. Is that showing up okay? That's weird.
Presentation mode.
Oh, okay. I know what you're saying now. Okay. Sorry.
That's okay.
All right, so presentation mode. Here we go. So this will be a little bit easier for you. So step one, determining copyright status. Does it have copyright protection? That image on the right is something you'll see when you get digital items that archives and digital collections will label that the item does not have copyright protection. It has that C with that just mark through it. So when you see that, that's a good indication that it does not have copyright protection, usually. But first, before we get into the public domain, I want to talk about copyright ability. So there are three conditions it has to meet. Creativity, I'm sorry, let me go back. So creativity, that's one of the most important elements of copyright protection in the United States. If it does not have any creativity, then it's just not going to have copyright protection. I will talk a little bit about table graphs and charts. So a lot of those don't have copyright protection because they literally represent data. If there is a level of creativity that is put into that table or graph or chart, it might have a minimal degree of copyright protection. So if you're using Excel to generate data, that typically is not going to have copyright protection. You didn't put any creativity into it. The software literally generated it for you. So when you're thinking about whether or not it has copyright protection, you can think about it in that aspect. Did I have to put any creative effort into it? And I can give you a resource that's really, really helpful that somebody published, well, basically depositing their repository on the copyrightability of table graphs and charts. And it's really helpful. They give examples and they cite some of the case law that has affected that. The best case law out there is Feist. Was sued by a rural communications company over a phone book, and they were saying that it was copyright infringement. And it went all the way to the Supreme Court, and they found that it didn't have copyright protection because even though it was called Sweat of the Brow does not get copyright protection. It took great effort to compile such a directory, but it actually doesn't have any creative effort put into it, and therefore they lost the case. And it was in 1990, I believe, and that was a really helped move copyright case law forward in terms of the liberty that we have to reuse others' works and what we can do with data.
So here's a question. You're talking about the copyrightability of charts and tables. And in that respect, you're talking about charts and tables as they stand alone. If they're part of a paper that someone has written, and the entire paper, the paper as a whole, does meet the creativity criterion, then because they're part of the paper, they are copyrighted just like the rest of the content of the paper is. Is that true, or am I wrong?
You could say that the entire paper has copyright protection, and this is my interpretation of it. And to be completely transparent here, I'm not an attorney, and everybody should know that this is not legal advice, but the way I talk to graduate students about this, and they usually come to me and they're like, I'm using all these figures and graphs, is this okay in my dissertation? And especially since it's going up on our public institutional repository where anybody can view it and find it, they will obviously have concerns, or really their advisors have concerns, and they send them to me. So the thing that I usually tell them is that you're using a piece of an entire work. And that piece, so for example, if you decide to cite a fact from an encyclopedia, that encyclopedia as a whole is a compilation and it has copyright protection. But if you cite a fact saying Thomas Jefferson was the third president of the United States, or something of that degree, you should still cite it, but it doesn't have copyright protection because it's a fact. Okay, so, and if you really want to get nitty-gritty into it, you could also make a fair use about analysis of it. So if something like that were to go to court, and I kind of doubt that it would, but if it did, they would probably first argue that it didn't have copyright protection. And if they couldn't make that assertion based on what you're saying that it's a whole work, then they would make a fair use assertion.
It doesn't sound like a big deal, but I know a couple of years ago, one of the big new things in e-resource, particularly databases, scholarly databases in libraries, was the ability to search not just an article based on keywords and searching text, but you could also search for individual charts and tables. So they were pulled out, the charts and tables were pulled out of the paper, and your search just became more granular. So not only were you just searching for the papers, you were actually searching for had the ability to search for the individual charts and tables. And I imagine that there was lots of copyright wrangling that went on as they were creating that capability. But it also then places a burden on the user of the results of a search. So thank you for that.
Yeah, that is really interesting. And I wonder sort of how that affects the market value of those tables, graphs, and charts, and so forth. So, and if that data visualization is creative, it does have copyright protection. So there's some really amazing data visualizations out there, and they definitely have copyright protection. But the really basic ones, and some of the ones that, for example, are reported in mathematics and engineering reports and theses and so forth, it's not very likely that they do. And if they were to put those in a database, I'm not sure what kind of copyright argument they can make for that specific type of graph or chart. But there could be something more specific in the license agreement when you're using that database that says what you can and cannot do with that. And that's where you have to start worrying about that rather than your fair use argument or your copyrightability argument.
That's a really good point, because they are still working on their license review assignment.
Yeah, and that's very interesting. My biggest thing is that there are licensing is very complicated. I am not an expert in it. That's why we have our e-resources librarian at K-State, and I have a lot of collaborations with her, and I don't think a lot of universities do that. I mean, I'm speculating, but we sort of kind of get in scholarly communications or digital scholarship, which is my field, we collaborate with a lot of people, but we're kind of in our own department. And then you have e-resources, and they're usually with tech services and other similar areas, and they're in their own corner. So the fact that we're kind of cross-collaborating, trying to figure out, and we're creating a LibGuide together, we're trying to figure out how do we answer questions for what you can and cannot do, and who should you go to when you have this question or that question. So that LibGuide is coming soon, and I will be happy to share it with you when it gets done.
That would be great, and I will share it with the class. Thank you.
So moving on, the next thing, okay, if it would click, there it goes, is originality. So this means that the work has to be original. This is mainly addressing one of the exclusive rights of copyright holders, in that they have the exclusive rights to create derivative works. And a derivative work can be a sequel, a film adaptation, a musical arrangement, anything that it's derived from. It's not an original work. Or maybe it could be just based on a character. So really prominent characters like Mickey Mouse have their own copyright protection because they're so well known. If it's just some generic character from a novel and you've never heard of it, it's not very likely it has that copyright protection. So that originality clause or condition is there so that other rights holders can't, or I'm sorry, other users create, if you're doing some creative work and you want to create, for example, fan fiction, that is something that copyright nerds like myself love to talk about because it's not really technically legal. There's like a gray area there, but the thing is there's never been a litigation, and for the most part, rights holders don't have a problem with it because it promotes their work more than it harms it. The fan fiction writers are not making money off of this. So moving on is the third factor, and this is also really important, is that it's fixed in a tangible meaning of expression. So it could be a digital format or it could be a physical format, but it has to be in some sort of medium. So I really like the example of choreography. It only recently got copyright protection, I believe, with the 1976 Act, and that's recent in copyright law. So, or maybe it was in 1990. I'm sorry, I'm getting my history there confused. Architecture just got protection in 1990. The thing about choreography, though, is if you go out in the street and dance, you don't just get copyright protection. You have to either record it or have some sort of annotation of it because it has to be fixed in that tangible medium. So dance is pretty interesting in terms of that because it obviously is creative expression. But you do have to have something there. So recording it's always a great way, like videotaping. There's lots of examples of this as well. I mean, music, if you're in the street playing music and you just compose a song that doesn't really even have copyright protection, you need to have it written down or you have to have it recorded. So, and after that, it does have copyright protection. I will also say, because I don't think I have this in my slides, is that there is a formal process that you can go through to register your work. And typically it's $35 per work. And there's an online form. You can do a paper form, but it's really, they encourage you not to do that. So after you do the online form, you get your work registered, you get more legal protection. And it's an incentive for people to register their works, and that gets registered through the Copyright Office, and then they hold that copy of your work at the Library of Congress. So that will forever be archived and you'll be part of history. So that also is nice. They want you to do this so that they have that record, but also so that you get these other legal protections. So for example, you cannot file a copyright infringement lawsuit until you've registered your work. So let's say somebody infringes, or you think allegedly they infringe, and you decide to register the work, and you can, but you're probably going to have to wait a few weeks to get that back. So in the meantime, maybe you wait, or maybe you send them a takedown notice or something of that nature, which I would recommend doing a takedown notice before you send them legal papers. That's my opinion, though. But you legally, you can just sue somebody without giving them any notice, though. So that's going to take a few weeks. And then on top of that, we have something in the United States called statutory damages. And you're only liable for statutory damages if the infringement occurred after you registered. And statutory damages are actually pretty controversial. We're I think the only country that does them. There might be a couple others, but for sure the United States has been looked down upon for doing them because they're based on the infringement per work. And so people who are doing file sharing, especially of music, which is the most litigated type of work, they're getting hit with sometimes millions of dollars potentially, just because there's so many files that they shared on a platform. So that can be worrying, and you have to think about, well, was it really that ethically wrong if they were doing this for them to get that much in damages? So moving on, sorry, I can be a little bit wordy. Public domain content you can also use. So I'm just going to briefly go over this. There's some tools here, and I'm happy to share my slides with you if you'd like to use them. I am going to actually start sharing just my screen so that I can show you at least one of these tools. I think that I'm sharing just my screen now. Okay, so anything created or published before 1923, for the most part, you're in a safe zone. There are a couple of weird cases out there where that's not the case, as in it was created and then somebody registered it, a few years later, but they're not very common. You can usually rely on that before 1923. Then you have these little gray areas between 1923 all the way to 1989. It gets to be gray areas. The easiest area is between 1923 and 1964, and that's because during that time you had to register the work and you had to provide copyright notice. And copyright notice just is a simple thing that says, either has that C with a circle around it and whoever the copyright holder is, your name, for example, or just copyright and then your name. So you have to have that copyright notice on the actual work, and then you'd have to have it registered. And then the term only lasted for 28 years, and then you could renew it for another 28 years. So that is something where a lot of people did not follow formalities during that time. It was more of an opt-in system, and now it's more of an opt-out system. I'll get to that in a little bit. So now if you're looking and you're like, okay, somebody published this in 1950, and you're not sure if it's in the public domain or not, there's this really great thing called the Renewals Database from Stanford. So the government did not create this. Stanford did, just to help people out finding copyright renewals. And so you can pretty much find most of the renewals in that database. The other thing to be careful about is this has to do with published. We have things called retroactive copyright law. And that means that if it was created and never published, it probably is still in copyright. That is unless the copyright holder died more than 70 years ago. So copyright term is life of the author plus 70 years for individual authors. For corporate authors, it's 95 years from creation, 95 years from creation, or 120 years from publication. I think I might have flipped those around. Sorry, whichever one is shorter. And so if you find a work that was created, and this is very, very true of historical photographs. So any library, and they want to be digitizing and putting up photographs, they're running into these issues. So we have documents out there that are basically about best practices for digitizing works like this, especially orphan works. And orphan works just means that either the copyright holder cannot be identified or cannot be located after a search. And I think the law, well, we don't have any actual law about orphan works, but we're supposed to undergo a laborious search, actually taking some sort of effort, but we don't have any type of guidelines based on that. So we just kind of have to guess how much effort is good enough to find or identify the copyright holder. So that is something that I think most librarians are going to run into, especially if you're getting into archives or digitization. There are really great documents out there for doing that legally and relying on fair use. So that's going to be your best friend. You can use this digital slider to, discover more of that. If you want more information, you just click on that and it'll give you some more context if you have questions. There are other tools on here, such as the Copyright Genie, and it just asks you, and it's also really cute, Copyright Genie. It asks you a series of questions, and you just answer them all, and it'll give you an idea of whether or not it's in the public domain or not, and when it will pass into the public domain. Okay. Okay, we already kind of talked about this, so I'm going to go on to step 2. And before we move on, Sarah, do you think we have any questions about public domain or copyrightability?
I can't think of any right at the moment, Rachel. I think the question about charts and graphs is about the only thing that has come to mind in terms of copyrightability and determining whether a work that you're going to maybe use in some way falls under copyright law or not. Right. So I think we're good. Thanks. You're absolutely right, and those watching will have just finished or maybe still be working on their license markup assignment. So they have licenses at the top of their mind, and we did talk about it. Everybody who's watched Jeannie Castro's lecture from last week will remember that we talked about the idea that that's one of the things that e-resources librarians negotiate for, is to make the terms of the license as close to copyright law as they possibly can.
And I apologize. I think I was muted for a couple minutes, so hopefully you heard me on Dr. Sutton's computer. So
I'll go back and double check it.
Okay, yeah, sorry about that. So if you see these, I mean, obviously for Kansas State University, you'll have one of those two icons pop up that will indicate to you that it might be licensed by the library. And we're actually got something put into our Search It that allows people to see the terms of the license. It's very, very like succinct and bullet pointed, but at least it does say whether or not fair use is allowed in those bullet points. So our e-resource librarian had that done, and I'm really proud of her for doing that. I don't know if users are using it or not, but I think it's helpful.
She probably managed that technically behind the scenes using an e-resources management system. That's my guess.
Mm-hmm. Yeah.
And we'll be talking about those coming up soon as well. So stay tuned. Not today, of course, but in the upcoming weeks.
Yeah. What she's talking about is the ERM. Our e-resource librarian talks about a lot, and that's something I'm not at all expert in, but it is wonderful though. So moving on, when you are sure that the license allows for fair use, for example, then you can make a fair use evaluation. Or if you are an instructor, for example, some of you might be going on to teach, I'm not sure. And then you can rely on some different exceptions, and I'll talk about those next. Posting online, if it's licensed, you should probably never do that. It's licensed for a reason. The libraries are paying for that access, and posting online is likely not a fair use, and it's going to violate the terms of the agreement. Okay, so Creative Commons, I'm going to show you a handout that I made to kind of explain the terms. So here's the basic terms that could be included with a Creative Commons license. And for those of you that may not be familiar with Creative Commons, it was developed, I think about 10 or 15 years ago, I think, by somebody who was Lawrence Lessig. He's a copyright expert and attorney and a professor. He's pursuing other areas now in his activism, but he developed it so that the digital world could have a permissionless environment to it. And it has really taken off, but it hasn't taken off on the scale that I think that it could be if we make people more aware of it, for example. So moving on, these are the basic terms of the license. It could have any combination of these. All of them have that the attribution on the far left. And that just means you have to give attribution or credit to the original creator. That's as simple as citing somebody. And there's no specific way that you have to do it. I always get questions about this. It just means you give credit. With the videos, a lot of times you don't want to be putting credit on top of images or media. So if you're putting a reference list, credits at the end of your video, that's also fine. The share alike, the next one, SA, means you have to share that particular, image or media or article with the same license. So you might be using just part of it, but you still have to share it with the same license. And that's sort of to promote more of an open access, permission-free culture. No derivatives is a little bit more restrictive, and I think that they're not as, Creative Commons is not, I'm not sure that they originally wanted to include that, but they also wanted to still have more people using it, so they did include it. And that just means that you can't change that work whatsoever. So you can't really condense it. You can't crop it if it's a photo. You can just basically reshare. So that it takes away the permission part, but it doesn't take away from, but you can't remix it and modify it and so forth. Non-commercial means that it can't be, you can't have any commercial purpose. So not only can you not make money with it, but if you are, for example, using a bunch of photographs that you found and they have that NC, that non-commercial on them, you also cannot use them in a commercial institution. If you're making, if you're in a band and you're making posters and you're promoting your band, you're not actually making money on the posters, but you're promoting something for commercial purpose. Or maybe you work in a commercial for-profit college, and that means you can't use any of those NC photographs as well. So there's a really good handout, and I think I'm getting low on time, so I'm going to move on, but I will link to it, and anybody can use it. Here's some examples, and this is an image from Flickr. Flickr's really has a lot of CC licensed photographs, so it's a great place to look for those. And so here's an original image on the left, here's a modified image on the right, and that's totally legal as a CC by NC SA license here at the top. So attribution, non-commercial, share alike. And so I'm sharing the photo. I was able to modify it because it doesn't say no derivatives, and I have to put the same license on it. So no matter where I share it, I have to put that license on it. Make sure that still anybody can share it as well. So here's some resources that people can look for. These slides were really directed at faculty, and so there's a couple here that are specifically for looking into materials that are open access. They may or may not have CC licenses on them, but they are open access, so that means that you can use them. You may, and that means they're freely available online. Doesn't mean that you still have to make a fair use evaluation, possibly, if it doesn't have a CC license on it. So that's just something to think about, or for asking permission. Again, this is going to be a case-by-case basis. So search.creativecommons.org is probably the best place to start, though. And, you can search for pretty much anything. Let's see if it pulls up. Did it pull up? Did the browser pull up? Okay. Make sure that's right. Oh, CC wants my email. So you'll just put here whether you want to use for commercial purposes, modify, adapt, or build upon. You can search. This is an aggregator. It's not an actual search engine, so you can just basically select which website or search engine you want to use. If you want to search for scholarly articles, there's not really a cut and dry way to do that. I usually have to type in a subject, and then I'll actually type in scholarly article. Otherwise, you're going to get lots of like Wikipedia pages pop up with those types of search terms. All right. Oops. Okay, moving on. Here's I also put in here the Google filter. So you just hit tools and then you go to the usage rights. That's pretty easy to do. And this is just for images. Same with Bing, it's pretty similar. All right, so we got to move on to step 3, and that's you want to consider the exemptions in the law. So let's say you found something and you want to use it. It doesn't have a existing license. It's not in the public domain. So here are the biggest exemptions. First thing is you want to make sure it's a legally obtained copy. Now, in the digital world, that's a little bit more difficult to do, mainly because there are terms of use on just about every single website you visit. And if they don't have terms of use, then you can assume that you have a legal copy for the most part. So when you get into that, you want to just go on the website and kind of search to see if they have terms of use. And the main keywords you're looking for in that license and that legalese document is, does it allow for your own use or your own personal use? And if that is true, that means you have a legal copy, and then you can make an analysis or an evaluation based on that. And mainly you're going to be relying on fair use, but if you're in education, you can also rely on these other exemptions. So section 110.1 and 110.2 allows for the performance and display of copyrighted works. 110.1 is really generous. It's in the face-to-face teaching settings. It does have to be a nonprofit educational institution. So for example, your community center and your public library do not fit into this exemption, and you usually have to get a public performance license just to show a film at one of those types of settings. Classroom in a face-to-face setting, they can show full-length films as long as it's related to the education of that course or class. So 110.2 gets a little bit more complicated, and that TCHAC checklist, it's a little bit outdated, and I've created something different and more up to date. So I will share those links. I'm almost done with it. And they not only have more specific provisions in there, but they're also say that it only allows for limited and reasonable portions of dramatic works. So that really limits 110.2, and that's mostly online distance education. So what's happened as a result is we're getting into these streaming services in the library. So if you end up in eResources, you're going to end up doing a lot of work with those types of licenses and really trying to negotiate rights so that faculty will either request specific films, and they will get them usually through Swank. I think you might know better. Yeah. So Swank is one of those sort resources that we use where you can, I think they can basically specifically request, can we get this film to stream for my course, etc. They're very specific about what you can and cannot do. But I guess it would really, I'm not the resources person. I'm not sure of all those exceptions, but Sarah or Dr. Seven could definitely tell you more about that questions. The other thing about both of these exemptions is that it really allows for that performance or display in the context of whether or not in the context of a class session. So this is what was challenging for me when I first started in this position that I'm in, is that 110.2, you have to think about it as if it was 110.1. So are you when you're showing, say, clips of a film to your class online, is it as if it was a class session? And if that's true, you can rely on 110.2. If it's not true, then you have to rely on fair use. In other words, if you're expecting students to do this in their own time, almost as if it was homework, that is not 110.1 or 110.2. This is like a class session. And works could be displayed. You might have artwork displayed all semester long, for example, or they need access to it all semester long. And that's kind of how you got to think about the class session. It might be up the whole semester, but it's really for them to have. Oh, my computer is about to die.
Pause for just a second.
Okay, thank you. Be ready.
Okay, and we're back.
Okay, so that is sections 110.1 and 110.2. They're linked here. You can go and read them. 110.1 is like about this long, and then 110.2 is, considerably longer because of all this specifications in it. So I would encourage you to read through it. And I'm going to get some updated links to my TCHAC. They're basically tables. And one is for dramatic works and one's for non-dramatic works, because it does allow for the display of non-dramatic works. And one of those specifications that is in 110.2 or the TCHAC. And TCHAC, by the way, stands for the Technology, Education, and Copyright Harmonization Act. It's a really fun one. And one of those specifications is that students cannot be able, the technology that's in place cannot easily allow somebody to make a copy of it. So a lot of these learning management systems need to be able to disable that download button. And if it doesn't, then you can't really rely on TCHAC. And that's why it's kind of a pain to rely on. So a lot of times faculty members are just relying on fair use, and whether they know it or not, because most faculty members that I talk with their understanding of copyright is it's for education, so it's fair, right? So that's kind of the myth around the exemptions and exceptions. So we're going to move on to fair use, and this is the really fun one. That's a really good tool to use for somebody who wants to familiarize themselves with those educational exemptions, and that one is too. They're both really great. So moving on to fair use. This is directly from the law, so Section 107 of Title 17, and it allows for, specifically for the purposes of criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research. This is verbatim from the law, so this is why teachers typically don't have a lot of issues with sharing copyrighted works with their students. However, there are 4 factors to fair use, and one of them is the amount that you can use, and we're going to get to that next. So the purpose, the nature, the amount, and the market, and we're going to go through each one. Here's the fair use evaluator. Oh, I need to go back. So I'm going to show you fair use on this tool because I think this tool is really excellent and is one of the best ways to learn fair use. And I encourage you to really go through all of the, not just the tool itself where you go step by step, but there are links in the beginning of the tool that you can review fair use, and it gives you a lot of great information. So, oops. Well, my link is not there. All right, I'm going to pull this up on here. So fair use evaluator is really easy to find. You can type it in and find it. Usually it's the first link. So we're just going to click, you can click on learn more about fair use and get a lot of information from that. But we're going to go ahead and make an evaluation. So I tell people, and I was talking to somebody just yesterday about her use of some photographs and figures. And so I had her use the tool. The tool is there not just to help you understand fair use and make an evaluation, but it will also produce a PDF for your records. And this PDF and these types of records and documents for making fair use evaluations are not legally required, but they are really beneficial because if somebody, especially if you're posting something online and you think maybe, well, you never know. Some things have surprised me why some people don't come after you and why some people do. And it never seems to make sense with context. It's just more the type of person that they are and why they do the things they do, or the type of company, such as publishers. So I know that you've reviewed the Georgia State case, and that actually really helped move fair use forward in terms of it not having bright line rules or checklists. So I will touch on that after I go through this. I tell people when they're making the fair use evaluation that they should put this information if they want the PDF, so it gives a lot more context, and that makes your evaluation stronger. This is date stamped and time stamped, and so this would help you in the rare instance that any litigation would occur, but also if somebody were to send you a takedown notice, you can show them this as a piece of evidence of your fair use evaluation before you used that work, and courts will see this as a good faith effort. So the purpose of your use. This is the why are you using it. So scholarly and educational purposes are typically in favor, but you need to think about, well, if you're showing a Disney movie to your 5th grade class, just so they will stop making noise, that's probably not fair use. In fact, I can tell you it's not. But if you're showing them a film about reptiles and it's related to the educational purpose of that class, that's fair use, or 110(1) rather of the exceptions. So you have to think about, is it really related to the learning objectives and so forth. Another thing you have to think about when you're doing a fair use evaluation is, do you need that specific work? If you find some photograph of a butterfly and you're making an analysis perhaps of the anatomy of the butterfly, and you are really, really needing that specific photograph, you're going to have a stronger case for fair use. If you could have found another photograph online that had an open license, such as a Creative Commons license attached to it, of a butterfly, and you used that other person's butterfly instead, that's not going to be a good case for fair use. Not as good as. So you really need to think about, do I need this specific item, and what is the reason for it? So with this tool, you want to pull up the Get Help in using this, especially if you're new to this. And I've used this. I've made my own fair use evaluations for some different purposes. And you can read through these and decide which ones are related to you and your particular use. For that criticism comment, that's the top one is related directly to the law. So then you can just click paste in the text and then it will do that. The second one down is the transformative use, and that's something that fair use litigation is really known for citing. Is transformative uses are typically in favor. And transformative just means that it changes the purpose of the original work. So parody is the best example of this. You have to really be parodying or criticizing that particular work and not just using it in a parody. So I'll give you two examples of this. South Park went through a lawsuit not too long ago and helped move fair use forward. They were making fun of some music artist. Now I can't remember who, but I would tell you the name of the song, but it's pretty highly offensive. I don't think it's that offensive, but I'm not going to say that here. So you can look it up. It's called How South Park Saved Fair Use. It's on YouTube. So they are making fun of that thing, and by making fun of something, you're in effect really criticizing it and commenting on it and giving it a little bit more perspective. Two Live Crew did their own version of Pretty Woman back in, I think, 1989, and they were taken to court over it. They actually did try to get a license for it at first, but they said no, and then they did it anyway. So they went to court, and they won, and it was a huge move for fair use, because that meant that even if it's a commercial purpose, parody is a fair use. If you're parodying something, you're not parodying the thing that you're using. That's typically not fair use. So somebody used like the Cat in the Hat language to make fun of the one of those famous lawsuits. Now I'm blanking. Well, anyway, they weren't making fun of Cat in the Hat, and they were making fun of something else, and they were using Cat in the Hat language, and that went to court, and it was not fair use. So anyway, I would encourage you to go through these. You can also rate them however you feel is best. Again, a fair use evaluation is a personal evaluation that the person who's making the evaluation makes. So I can't make one for you, and typically a lawyer can't either unless they're your personal attorney that you've hired, and they can, and then that's something altogether different. The nature is going to be what kind of use you're using. So factual works are more in favor than creative works, but that doesn't mean that you can't use creative works. There's plenty of fair use litigations that has moved fair use forward, and they've been creative works. So that's just something to think about when you're making fair use evaluation, whether or not you're in favor of it or not. So you can rate it again, depending on how you feel. The amount used is the quantity and the quality. So the quantity is pretty obvious. There's no bright line rules, and this is something that the Georgia State case really helped. When it went to the Court of Appeals, they pretty much said that everything that the district court said was incorrect, that there's no such thing as a 10% or one chapter rule that has been cited in previous court decisions and by the district court in that case. And the problem with that is that's kind of been a bright line rule for a while, but it's never been part of the law. It's something that publishers sort of made up to give libraries an idea of how much they could use, for example, for interlibrary loan. But it's never been a law. And then for some reason we started adapting that and adopting that as a practice, and then a guideline, and then it became a checklist, and then it became a rule. And it just kind of evolved into this thing that never should have evolved into. So the amount used should be the amount that you need to complete your objective. And that's as much as I can tell you. And you should make the amount used should also be considered in the fourth factor, which I'll get to next. It's the market, the effect on the market value. So the thing about the amount is it's not just the quantity, it's also the substantiality. So if you're using the heart of the work, that means that you might be affecting that market, that fourth factor. So all of these factors tie together and they're interwoven. So if you are, there was a lawsuit involving the, I'm blanking again, Nixon, the Watergate scandal. So there's a biography written about Nixon, and the Watergate scandal was the biggest part of that book. And there was a magazine that published just that chapter, and the publishers went to court over it, and it was not deemed fair use because it was the heart of the work. So you have to think about that as well. The effect on the market, this is the part that usually confuses people the most, but you really want to take all three of those factors together to make an evaluation of how you might be affecting the market. If you are taking DVDs and streaming them online for free, that's going to affect people, you know, the market of those movie producers and so forth. That's an obvious example. And not so obvious examples if you're taking photographs from somebody's website and you're putting them on your website, and maybe that person's a photographer, and you might be taking away from their market value because they're trying to market themselves as a photographer, and you're putting them on your own website, and you're not citing them, and you're not, you know, linking to them, and that's really harming their own market as a photographer. So you just have to think about this in a logical way, and think about fair use in a golden rule way. If you're that copyright holder, how would you want to be treated? And this is all about ethics. And there's been some really great cases that have helped move fair use forward. And I would say we're actually fairly fortunate in the United States to have the fair use provision, because it does really help with giving us more liberty to use others' works. It's just that people are afraid to use it. So if you can get some practice in with it, I would encourage it. Here at the end, you can then mark whether it's fair or not fair. Then you hit the create a PDF, and it'll bring up all the information you just put in. And you can keep this for your records. So it's really useful. The last thing we'll talk about, and I don't know that we have time to talk about author rights because I've already talked for an hour, so apologies, is we're going to talk about permissions, and I'm not going to spend a lot of time on it. There are some slides in here about using tables and graphs, so you can review those as well if you're interested. And I have some examples related to what is and is not fair use. So this is a pretty simple step. If you have gone through these steps and you've determined it's not in the public domain, it doesn't have a license, and you really can't rely on an exemption, especially if you're using something like for really decorative purposes, like on your website or something like that, you can either seek permission, purchase a license, or get an alternative resource. So obviously get permission, but sometimes it's hard to contact copyright holders. And there's a lot of third-party agencies that license works, especially for music and film. So if you want to get the rights to screen a film at your local library or something like that, or even at the university, that classroom exemption only applies to the classroom. So if you want to have a film screening or a film festival at your university, you have to get those public performance rights. And there's a lot of different resources out there for that. It's pretty easy though. So like I said, buy a license, or use a comparable work. Like I was talking about with finding that photograph of the butterfly, you know, if you can find something else out there that is similar that will work for your purposes, then do it. And then you don't have to worry as much about all those permissions and exemptions. All right. I'm gonna ask you if we have time for author rights, but I'm guessing we don't.
We should probably start here, but if you are willing to share your slides, I will share them with everybody so that they can have a look at the slides as they go along through your talk, and then look at the slides that we
Right.
that we didn't get to. But I do have one question for you.
Sure.
Does K-State use the Copyright Clearance Center?
We do not use them as a service. Very rarely I will direct people to that if they for sure cannot rely on fair use.
Okay.
But I always talk about fair use and copyrightability before I go there.
To the copyright.
Yeah, we don't pay for a subscription there. A lot of universities do, but we do not.
The Copyright Clearance Center is as Rachel mentioned, a subscription service to which an institution can subscribe, and it gives them some additional copyright permissions. It not only does it give them what they're paying for, some additional copyright permissions, so that if there was a work that, for instance, a faculty member wanted to use that was protected by copyright and required permission, the Copyright Clearance Center acts as a clearinghouse, hence the name, to obtain copyright for that particular work for the institution. Sometimes there is an additional charge to it in addition to the institutional subscription, and sometimes there's not. But as Rachel said, there are a lot of institutions that do subscribe to it, including the institution that I worked for when I was an e-resources librarian, and I found it, that was a small institution where not only did I do e-resources, but I also did copyright education for our faculty members, and I relied very heavily on the Copyright Clearance Center. So there's that. Well, Rachel, thank you so much for your time and sharing your expertise with us. I really appreciate it. I'll go ahead and stop recording now.
Yeah, thank you for having me. Maybe if anyone wants to ask me questions, you can reach out to me. I think my email's on the presentation slides that I'll share with you, but it's ramiles@ksu.edu. And if you want to ask me about author rights, that'd be great too. I think that reusing copyrighted works is more applicable to library settings, but if you ever have questions, just let me know.
All right. Thanks very much for your attention, everybody. Take care. Talk to you soon.